accusation calendar. This is a list of misdemeanor criminal cases in which individuals were recently arrested and booked at the Fulton County Jail. Upon being processed through intake, the Fulton County prosecutor, which is the Solicitor General's office, has already formally accused the cases, and hence this would be the defendant's first appearance with a state court judicial officer. During the course of this civil proceeding, which we are handling through a virtual format, which is also recorded and live streamed, please take note of your rights, and this is specifically for the defendants. You have a right to remain silent during the course of these proceedings, which is recorded. Your statements can and will be used against you in the treatment of your case. So please do not say anything unless you have the advice of counsel. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. When I call your case, I'll let you know what's the accusation number brought against you. What are the charges that are going to be, what are the charges of which you've been formally accused? Who's going to be your attorney? What is going to be your bond if one has not been previously set, as well as to give you a court date. I want to just make sure what my next court date is, and that will be from Ms. Lewis, is it? Or who's our litigation manager?
Good morning, good afternoon, Judge. This is Katrina. Ms. Grace is going to be your case manager for the SEA counter, and I'm going to be the LM for the final plea counter for the cases that we did not was able to address yesterday on the SAP counter.
Okay, and Ms. Grace, do you know the reset date, please? Is it, you know what, I just want
June 1st, June 1st.
All right, thank you, Tony, thank you. So, yes, we did have a little procedural hiccup yesterday at the C calendar, and are the 3 pleas ready to go?
Thank you, Your Honor.
Go ahead, Mr. Dotis.
Apologies. I am speaking with my clients at ACDC right now. Due to the power outage, I was not able to fully address their situations yesterday. I have one more client to speak with, and then I'll be happy to address the court.
All right, just let us know when you're ready, and I guess we'll take it up at that time, okay?
Thank you, Your Honor. I'll start my video again to let y'all know. Thank you.
All right, thank you, appreciate it. Okay.
Position number 3 at ACDC, the conflict, Ms. Conley.
All right, thank you. This is State versus Kaisha Conley, accused of misdemeanor willful obstruction of a law enforcement officer from May 17th, 2023. Ms. Conley's accusation number is 23 CR 0031778. Ms. Conley, you've been advised of your right to remain silent, and your attorney is Ms. McLeod. And Mr. Howard, any priors? Okay, got it. This is a first arrest. And Mr. Jones, good afternoon. What are you recommending for Ms. Conley?
Good afternoon, Judge. So the state is recommending $1,000 surety bond. This is for the fact of the state has a concern of the intimidation of witnesses. The defendant works at the hotel in which the victim, Mr. David Dow, resides, and the co-defendant is actually the son of the defendant. Also, we believe that the defendant is a danger to the community. She refused to follow the officer's commands to step back during the arrest of her son. Your Honor, at the appropriate time, we're going to ask that you sound for the victim just in case he is on. But Your Honor, those are the reasons of why the state is asking for the $1,000 surety bond.
Okay, and I'm assuming Yasir Conley is at courtroom 2? Courtroom 2, is that Yasir Conley?
This is Mr. Conley.
All right. In courtroom 2, Mr. Conley is seated. This is Yasir Micah Conley, 23 CR 0031788. And Mr. Yasir Conley is represented by, is it by Ms. Willis? Ms. Wills, excuse me. Ms. Wills, can you do a test 1, 2, 3?
Yes, can you hear me?
Oh, yes, I can. Thank you. All right. And this is Mr. Conley's first arrest as well. And so for Ms. Conley, you're recommending $1,000 surety bond. And what are you recommending for Mr. Conley, who's accused of battery and willful obstruction of an officer?
Yes, Your Honor. So for Mr. Conley, we are recommending a $2,600 surety bond, $2,000 on the battery count, $600 on the willful obstruction of a law enforcement officer. For the reasons of A, the intimidation of witness, the defendant was at the hotel where the victim resides. We aren't for sure what Mr. Conley was doing there. In addition to that, he followed the victim to his room and attempted to prevent the victim from closing the door. Once he gained entry, he struck the victim several times in the head. Therefore, in addition, the defendant has no regard for police officers. After being told to put his hands behind his back, he began to resist, forcing officers to use trained techniques and refusing to follow lawful commands, Your Honor. That is the reason for the $2,600 surety bond. Again, that's the $2,000 on the battery count and $600 on the willful obstruction of a law enforcement officer.
All right. Mr. I think his name is Dow, D-O-W. Are you present? Mr. Dow. All right, there's no Mr. Dow. Ms. McLeod, what is your recommendation for Ms. Conley?
My recommendation, good afternoon, Your Honor. My recommendation for my client is a signature bond. Miss Conley is 39 years old. She's never been arrested. She's never been in any kind of trouble. She works at this hotel, but she also lives there. She tells me that she is a victim of domestic violence, and that is why she's actually living where she works right now. And her son, who is a minor, he's only 17 years old, also lives there with her. She tells me that the alleged victim actually tried to attack her. He was shouting at her and he threatened to shoot her. And so she started to scream. And when she was screaming, her son heard and came to her defense. And this is essentially what happened. She denies that she was the aggressor at all in this case. She said that the gentleman in question wasn't even supposed to be on the property because he had come there last week and had been misbehaved and had been told that he should not come back there. But when he came there, apparently they did not recognize it was the same person when he was actually allowed to come back there. So he's not supposed to even be there. Given the fact that my client is 39, never been in any trouble, Your Honor, I would say that no one could say she's a danger to the community in any way. And what she was trying to do was to explain to the police officers that her son had special needs and that they should be more careful in how they were handling him. They were actually beating up her child in front of her, and she was trying to explain to them, like, look, my child has some special needs, and you shouldn't do that to him because it's gonna, it's gonna be bad for him. That was all she was doing, Your Honor. Based on that, I would ask the court to give her a signature bond so she can get out of jail. At any rate, she has no money to pay to get herself out of jail or even her son. That is her current situation. She's essentially homeless and living where she works. Nothing further, Your Honor. I'm
sorry, she works at the Travel Lodge and she lives.
Yes, she does. She works there and she is living there at the moment because she had to leave her home because she was a victim of domestic violence.
Is she still employed there?
She is, Your Honor.
Okay. Ms. Wills, do you have anything to add?
Yes, Your Honor. Mr. Conley, as it was stated, he is just 17 years old. He is scheduled to begin summer school in June. I'm going to echo some of what Ms. McLeod said. He did hear his mother shouting. He saw this man accosting his mother. He has been witness to the domestic violence that his mother has suffered. And so he did go downstairs to where Mr. Dow and his mother were to defend his mother. Again, he is just 17 years old, very young, and did not. Well, he went downstairs to defend his mother. As far as the obstruction, my client reports that the officers grabbed him without warning. So he was confused and surprised that he was not trying to resist arrest. And again, Mr. Dow should not have been on the premises to begin with. So for all of those reasons, I'm also asking for a signature on bond, Your Honor. And he was living at the hotel with his mother at the time this incident occurred.
And I'm sorry, what do you mean by David Dow was not permitted on the premises?
He had been there the week before, apparently, Your Honor, had been asked not to come back because of his conduct at the time. And when this incident happened, he was visibly intoxicated.
Your Honor,
tells me.
Yes, Mr. Jones.
Your Honor, just to kind of clear the facts up of what the actual police report says, Mr. Dow went to the front desk to get a key for a room. In fact, both of the defendants followed Mr. Dow back.
Oh, yeah,
to
I
the,
saw that part about the video footage. What I'm concerned about is whether he's still staying there.
Unfortunately,
We can't, Your Honor.
we have
No,
not been
Mr.
able to
Cloud,
have.
please.
We have not been able to have contact with Mr. Dow. So out of the sake of cautiousness, for our victim, we would ask for a stay away and no further contact.
Okay. I have a Zoom user wearing a hood. What is your name, please?
Me,
Yeah.
Lamar Scott.
Okay, thank you. Please mute yourself. I have an iPhone user. Could you please start your video and identify yourself?
Judge, I turned off her video because I tried to get her to identify herself and she was moving around.
All right, iPhone user, please start your video and identify yourself.
Everything.
It won't let me turn the
Okay.
video on.
So we're going to have you removed from Zoom, and then when you come back on, make sure your video and your audio are both working. Ms. Lewis, please remove iPhone from the Zoom. All right, so I don't have a Mr. Dow here at the present time. On Ms. Conley, her bond is going to be set at $3,500. It's going to be a signature bond through pretrial services. She's to have no further violent contact with David Dow, and she can return to the property at the Travel Lodge, which is 3717 College Street, on two conditions: as long as she is still employed there and Mr. David Dow no longer resides at the property. Those are the only two conditions that must be satisfied. Both must be satisfied in order for her to be able to return to that property. So she needs to confirm with the employer that she's employed there and that Mr. Dow no longer resides there. And then she may, otherwise she's permitted a one-time visit with an officer to retrieve her belongings. And she needs to stay away from that location as long as Mr. Dow still lives there. No illegal drugs, no alcohol, and no weapons. On Mr. Yasir Conley, same bond amount. On the battery is going to be $2,000. On the willful obstruction is going to be $1,500. The bond is set at $3,500. Signature bond through the pretrial services to have no contact with David Dow and to stay away from 3717 College Street, the Travel Lodge Hotel, as long as his mother is no longer employed there and Mr. Dow resides there. He's permitted to return with an officer one time only to retrieve his personal belongings. When they return with the officer and it is confirmed that Mr. Dow has left the premises and that Miss Conley still has a job there, then both of them can return to the property. Both of you, your next court date is going to be sent to your current mailing address. So if you no longer reside at the Travel Lodge, you must update the court with your new mailing address within 30 days of being released. Thank you.
All right, hold on. I got
Thank you.
two things. Number one, Melissa, that's per judge. Number two, judge, who gonna co-sign for him? Because he's 17. And his mom can't do it 'cause
That would be his mom.
she in custody, judge. How's she gonna co-sign?
When y'all interview her, y'all can get her to also submit the form.
I don't know if they do it like that now. I'm just
Um,
saying.
Mr. Tucson Howard, I have absolute faith in your ability to get it done.
I'll mention it to him, but
All right.
that's out of my control, though.
All right, thank you. Okay, that is the Conley cases. Mr. Dotis, what is Ms. Traquanta? Are you a witness or a victim? All right, just make sure you're not driving while you are on Zoom. Okay, thank you. Mr. Dotis, are you ready with your pleas?
Yes, Your Honor, we are ready to proceed. I will note for our final plea calendar, position 1 will be a non-negotiated plea. For position 2, Ms. Brittany Jackson, we would request to be heard on bond. I know this is a final plea calendar, but that was our intention yesterday before the power outage and it was reset. And position 3, Ms. Tamika Johnson, that should be a negotiated plea.
All right, and all of them are at the at the Union City location, correct?
Yes, Your Honor, they should be at ACDC South Annex 1, and I did speak with all of them.
All right. Let's address Tamika Sharita Johnson. This is State versus Tamika Sharita Johnson, case number 19 CR 0094268. Ms. Johnson was accused of DUI, driving under the influence of alcohol, less safe, reckless driving, violation of basic rules, too fast for conditions, driving under the influence of drugs, less safe, and DUI, driving under the influence of alcohol and drugs. Those are the 5 misdemeanor charges that were brought against Ms. Johnson from an August 27, 2018 incident. This matter was supposed to have been addressed on Thursday at the SAP calendar, but unfortunately, due to logistics, we're addressing it today. Ms. Johnson, you've been advised of your right to remain silent, and your attorney is Mr. Angelo Dodis. This is going to be a plea hearing. So, Ms. Johnson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Ms. Johnson, can you hear me?
You froze a minute there, Your Honor.
Okay, let me repeat. Ms. Johnson, do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Dodis?
Yes, Your Honor, my
Oh,
understanding.
sorry, not Mr. Dodis. Mr. Jones, Scar, you're
I was
always.
going to punt it to him anyway.
I need
Thank
to
you.
put your 2 Zoom panels separate from each other. Okay, there we go. All right, go ahead, Mr. Jones, please.
Yes, Your Honor. So the state's recommendation is going to be 12 months to serve 120 days. Credit for time served 61 days. The balance is going to be probated with a $300 fine, 40 hours of community service, ADET, a risk reduction, and an FVIP. Your Honor, this will all go to count number 1 of the DUI. Counts 2 and 3 will merge, and the state will no process 4 and 5.
Okay, 2 and 3 will merge, and 4 and 5 are null pros. And I'm sorry, did I hear you say a FVIP?
FVIP.
My understanding is VIP.
VIP.
I don't, yeah.
Okay. Victim impact panel. Okay, understood. Okay. All right, and Mr. Dodis?
Yes, Your Honor, that's our understanding of the offer. I communicated that offer to my client, Ms. Johnson. We're prepared to go forward with it, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea to allow Ms. Johnson to get back on her feet since she has been in custody for, I believe, 60 days. We would request this court to waive a few months of her probation fees and allow her to switch to non-reporting status upon completion of all conditions.
I will waive it through the end of July 2023, but I will not put it on non-reporting. This is a DUI of both alcohol and drugs. Even though it's just pleading to just alcohol. And also there'll be random screens throughout the probation year. Shall I proceed, Mr. Dodis?
May I ask Ms. Johnson if she understands that after starting in July, you'll have to pay probation fees?
Starting in August 1st.
Excuse me, I'm sorry, August. Thank you, Your Honor. And that there will be random drug screenings if you choose to go forward with this.
Yes, I do.
Okay.
I understand.
All right.
Okay, we're ready to proceed. Thank you, Your Honor.
Ms. Johnson, are you have you consumed any medication or alcohol recently?
No, I just take the medicine, insulin. I'm diabetic.
Okay. And after consuming that medication, are you still able to understand the proceedings so far?
Yes, ma'am.
And
Yes,
and are you satisfied with your attorney's services?
Yes, I am.
Has anybody forced you or induced you to take this plea offer today?
No, I haven't.
And has it been explained to you that if you decide to plead guilty to this DUI conviction, it will be to a DUI charge, it will be a conviction on your driving record?
Yes.
And it will also trigger a license suspension?
Yes.
And do you also understand that in order for me to accept your plea, that you would have to give up your right to a trial, to go before a judge or a jury, to confront your accuser, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give these rights up?
Yes, ma'am.
How do you plead to one count of DUI under the influence of alcohol, let's say?
Guilty.
Your sentence is 12 months to serve 120 days, credit for time served 61 days. Your jail time is concluded and you should be released within 24 hours if you have no other cases holding you at the jail. Once you are released, you have to report to probation next Thursday at 132 Mitchell Street in downtown Atlanta before 3 p.m. Do you understand?
Yes, ma'am.
And while you're on probation, you will comply with the following conditions. You will not consume any alcohol or illegal drugs. You will be subject to random screens. I will waive your probation fees up to and including the end of July 2023. You will start paying probation fees from August 1st, 2023 onwards till your probation term is over. While on probation, you will pay a $300 fine. You will complete 40 hours of community service at any nonprofit agency. You will complete an alcohol and drug evaluation at a qualified healthcare provider's location and submit yourself to any treatment that's required. You will also complete a risk reduction program and attend and complete one victim impact panel. Your counts 2 and 3 are going to merge with the DUI under the influence of alcohol, let's say, and counts 4 and 5 are going to be null pros. So Mr. Jones, please submit the null pros orders to Ms. Lewis as soon as you can.
Yes,
Any
sure.
questions, Mr. Dotis?
No, Your Honor, just to clarify, can I send all paperwork to Ms. Lewis or am I sending it to Ms. Grace?
Ms. Lewis, I thought we had the paperwork.
No, because he did not know if what was going to be out with the pleas.
Yes.
Submit the paperwork to me, Mr. Doris, since I work the calendar. That's why I did
Okay.
it.
That's
So
what
everything
I
comes to me.
thought, but I wanted to make sure.
Yeah,
Yeah.
everything
So
comes
this-
to me, Mr. Jones, the null process, everything comes to me.
All right, thank you. Thank you, Ms. Johnson. All right, the next case you said that was going to be a non-negotiated plea. Was it Haywood or Jackson?
It is Hayward, and we will also be requesting to enter a NOLO plea for this case, Your Honor.
All right. This is Tamia Sion Haywood, case number 23 CR 002773J. Ms. Haywood is accused of criminal trespass and causing damage to property and battery domestic violence from May 3rd, 2023. Ms. Haywood, you've been advised of your right to remain silent, and your attorney is Mr. Angelo Dodis. This is going to be a non-negotiated plea hearing, which means that first I'm going to hear from the prosecutor as to what the recommendation is if you decide to plead guilty or no contest to the charges. And then I'm going to hear from your attorney as to what the recommendation should be if I accept a no contest or nolo contendere plea from you. So please keep in mind that I also have the discretion to disregard either recommendation and set the case down for trial. So Mr. Jones, I'll begin with you first.
Yes, Your Honor. Do we want to hear for pretrial or do you want me to give you her history?
You can go ahead and do so, Mr. Jones.
All right, so the relevant history is going to be case number 19 CR 14008. That was discharge of a firearm while under the influence and reckless conduct. The next one is going to be 21 CR 002411A, which was a criminal trespass, simple assault, and terroristic threats. So on May 3rd, 2022, officers responded to a dispute call where the defendant attacked her mom, whose name is Judine Hayward. Ms. Hayward attempted to gain access into a bedroom and noticed that her door was damaged and locked. While she attempted to get behind the door, the defendant began acting aggressive and became verbally aggressive. As the situation became more stressful, Ms. Hayward advised officers that she pushed the defendant, and which led to her being attacked by her daughter. Your Honor, the state's recommendation for this sentence was 12 months to serve, 90 days, credit for time served 16 days, balance probated with a stay away and an FVIP course.
Is there no contact as well? I'm assuming
No contact as well.
All right. And is the state willing to accept a nolo contendere?
We would object to a nolo contendere, Your Honor.
All right. Mr. Dotis?
Thank you, Your Honor. We would request to enter a plea of nolo contendere. Ms. Haywood has not used her nolo in the past 5 years. I also didn't hear a final disposition on either of those two cases. Ms. Haywood, we are fine with the terms of probation. We're clear that at this time there will be no further contact with the mother based on what we've heard from the state. And we're clear that a family violence intervention program needs to be entered into immediately after reporting to probation. Our only issue is jail time. Instead of the 90 days, we're asking it to read to serve 32 days, credit for time served of 16 days. That will allow Ms. Haywood, who's currently working at the Swissport cargo handler at the airport, to return to her job. It's her understanding that that job is waiting for her at this point in time, but that will not be waiting for her indefinitely. We want to set Ms. Haywood up for success on probation. The family violence intervention program, I've gone over it with her and she knows how extensive it is and that she will be responsible for the cost herself. So we do want to make sure that upon release, she has a job waiting for her so she can meet those payments. Additionally, she was living at the incident location and she is clear that there will be a stay away. And so now she needs to find housing immediately. And in order to do that, she needs an income. If we put this off and she's in jail and loses her job, upon release, not only will she, be on this family violence intervention program, but she'll also have to find housing and find a way to pay for it. So we are asking for that opportunity for Ms. Haywood to be set up for success and released into the released in order to be successful on probation and hold her job in order to find and maintain housing. Additionally, as regarding the facts, she was living at the incident location. It's also based on the affidavit for arrest. It looks like the alleged victim is the one who started the physical altercation by pushing my client. And if you look at the booking screen, the picture of my client shows significant bruising around the face. So both my client and the alleged victim were in a physical altercation with each other. It wasn't just one person beating on the other. My client does want to have a relationship with her mother, but she does understand that that's not an option at this time. But hopefully there is an opportunity for reconciliation down the line. While in custody, Ms. Haywood has started the New Beginning program at the ACDC facility for family and personal counseling. She took that initiative. No one asked her to do that. She spoke with them and that program will be available when she's out, and she wants to voluntarily continue doing that. Down the line, she also wants to have the opportunity to start counseling with her mother to reconcile that relationship. But she is clear that while that no further contact is in place, that won't be an option. Based on the fact that she's been in jail for 16 days in the cooling off period, again, I think that now she understands what she needs to do. She can't go back to the incident location, but she will have that job waiting for her to allow her to find and pay for housing and get started on the family violence intervention program. So we would just ask it to read as served 32 days, credit for time served of 16 days to allow her to get started on that.
All right. On the 19 CR case 1440, Ms. Haywood was originally accused of a misdemeanor offense. It has since been transferred to the Superior Court as a more serious charge. So that's still an open case right there. On the 21 CR case 0024118, Ms. Haywood did plead guilty to terroristic threats, and the case was disposed of in December of 2021. This is now her third case involving violence, and even though there may have been a cross-defendant, I honestly can't recall, but this is too many cases alleging a violence within a very short time span. the court will accept the state's recommendation, and I will permit Ms. Haywood to plead guilty to the battery, domestic violence, and nolo contendere to the criminal trespass causing damage to property. Her sentence would be requiring her to spend the additional time in jail. So she's been given credit for 16 days. So I think she has 25,
Those are 29 days, Judge.
29 more days left. Is that something your client would like to do, Mr. Dotis?
I think at this point in time, I need to speak with my clients. If we could hold on that and move on to Ms. Jackson, I can speak with her, either a phone call in a breakout room.
All right. And next case is Ms. Jackson. Do you still need to speak to her? Or are we moving on with this?
Your Honor, I have spoken with Ms. Jackson. This is we would ask to address bond today.
All right, just 1 second. If everyone please hold for 1 minute, I just need to adjust one technical issue.
Judge, you're on mute.
I do beg one. So sorry. This is State versus Brittany Jackson. Her first appearance was on May 5th, and a bond order was entered for $3,500 good bond. And Ms. Jackson, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Yes, Mr. Dotis, what are we doing today?
Yes, Your Honor, we would ask to address bond.
Grounds?
Your Honor, my client has been in custody for 15 days on a $3,500 surety bond that she cannot afford to pay. So we would ask for that to be readdressed.
Okay. Mr. Jones, I don't know if you were the prosecutor at that time, but what is your response?
Yes, Your Honor. So based on the facts of the case where that involves a minor, and we actually spoke to Miss Linda Barton, which is the person that walked in and actually observed the defendant choking her minor son. And in fact, Miss Barton has stated that this isn't the first time, and that she's really fearful of the defendant causing seriously bodily injury to the child or even death, as this happens quite frequently. The minor also confirmed the incidents of being choked by his mother. Therefore, the state's recommendation is going to keep the bond where it is at the $3,500.
All right. Mr. Howard, do you have any priors? If you can refresh our memory, please. Oh, Mr. Jones, if you have his GCIC?
The only prior I have is driving without a valid license from 2021.
Okay. Anything else, Mr. Dotis?
Yes, Your Honor. My client is 32 years old. As stated, she's been in custody for the past 15 days on a $3,500 surety bond that she cannot afford to pay. Looks like the only history was one driving charge. I didn't hear any FTAs or VOPs. I have a good phone number for her. I also have a steady address for her, and she has been in the state of Georgia for the past 5 years, so I do not believe she'll be a flight risk. She did attend trade school where she got her OSHA certification in construction staffing. She's currently working with People Ready Staffing and believes she can return. She's also starting to work more in the construction field with Willie Love, who is the father of a separate a child that she is pregnant with. Miss Jackson is a mother, and besides the alleged victim, who I will address in 1 second, she has a 6-year-old child, a 3-year-old child, and she's currently pregnant with Mr. Willie Love's child, who I did speak with. He was on the Zoom yesterday, but he could not be here today due to the rescheduling and taking off on work. I spoke with Miss Jackson regarding the alleged victim, and she tells me that he's currently receiving behavioral health treatment from OGCC.
Your Honor, we're going to object to this. I don't think that what the victim is receiving or any treatment is here and should be considering for bond. We are here to discuss what it is that the defendant did on this particular instance and what the police report states.
I'll agree with that.
That's fine,
Mr. Dotis, yeah, that would not be appropriate information to air, especially for a minor. What I'm more concerned is what is the custody status right now of the
Your Honor.
minor?
Your Honor, I did want to address that. The child is currently with a neighbor, Miss LaQuanva Smith. I have a contact number with her. She's willing to watch him until a permanent placement is arranged. Miss Jackson, and if prior to this incident, Miss Jackson was working on securing a bed for her child at a facility, but she understands that moving forward, if she is released, that visitation will likely be limited to supervised visitation. She's fine with that. She understands that right now it's not in the best interest of her, or and especially her the 13-year-old alleged victim, for them to be, in any other type of relationship. She wants to have supervised visitation to make sure that the child can be transferred from the neighbor to the father's side of the family, since they're more familiar with his situation. I have a number. Miss Jackson did not have a.
I'm sorry, with the minor's father?
The father's side of the family. I don't believe it's the father will be involved, but I do have a name, Antoinette Bolton. I don't have a phone number. Miss Jackson, my understanding is the number is in her property, and while she's in custody, she can't get that. But to ensure that the child is receiving the care he needs and is transferred to more secure housing on the father's side, to ensure that there's no more future incidents, we would request a signature bond with the condition of no further contact unless supervised, to ensure that that child is able to be transferred to permanent, stable housing.
The bond is reduced to $2,000 surety bond. Under the circumstances of this case, that's as low as it gets. I'm not going to consider any modification. I'm going to enforce the same contact requirements. She's to have no further contact with the alleged minor child, and that any contact must be in accordance with the visitation schedule established by defects and only supervised visitation. With regards to any placement of the child with any other family, including the biological father's family, that must be strictly scrutinized by defects and to determine whether that's an appropriate course of action. This is not a course of action that can be taken unilaterally by the defendant or the defendant's family. Any placement of the child with any other family, including the family of his biological father, must be strictly scrutinized and administered by defects only.
Understood, Your Honor. I'll prepare that paperwork. Thank you.
Thank you.
Your Honor.
And so, Ms. Lewis, I think we are going to address the Brittany Jackson case shortly. So I'm going to get back to my first appearance calendar, okay?
And
Yep.
Your Honor, if I just may, while I'm on Zoom, if I could request
Yes.
Milton to call my cell phone so I can speak to Miss Jackson, Miss Hayward, excuse me.
All right, all right.
Thank you.
Deputy Milton, at your convenience, if you could contact Mr. Dotis so he can speak to Miss Jackson.
Yes, I have Miss Gantt, position number 7. Come on, Miss Gantt.
Is there a co-defendant, a cross-defendant in this case? Anyone knows? No? Okay.
Yes, Your Honor. There was a juvenile arrested in this case, I believe.
Okay, so we just, this is position 7, Denicia Jamette Gantt, accused of simple battery domestic violence on May 17th, 2023. Ms. Gantt, you've been advised of your right to remain silent, and your attorney is Ms. Kelly Wills. In your accusation number is 23 CR 003166G. Mr. Howard, any priors?
Second arrest, 2021, trespass, DV, dismissed.
Mr. Young, yes, sir. Any recommendation?
Yes, Your Honor. The state's recommendation is going to be a $3,000 charity. Stay away from the incident location. No further contact with the victim. On 1 day anger awareness. The reason being that on May 17th, at 28 Baldwin Avenue, Southeastern Atlanta, the defendant and the victim got into a verbal altercation that turned physical in the hallway at this location. Witnesses there, one being the minor victim's father, stated that they just began fighting. No one was able to identify who threw the first punch, with that being what resulted in both parties being charged. The defendant did have visible marks, injuries to their back, and the victim had a mark on her forehead. So both also had visible injuries. So with that being said, again, the state's recommendation of $3,000 charity bond, stay away from the incident location, no further contact with the minor victim, and 1 day anger awareness.
Okay, thank you. Ms. Wills?
Thank you, Judge. My client is 18 years old. She is in the 11th grade and working on obtaining her GED through the Atlanta public school system. She does not have any children and she is currently unemployed. Ms. Gantt tells me that she was attacked by the minor. And again, my client is very young also. So this is a minor that's in her teens, 14 or 15 years old, that the minor had previously stolen from her. There was an argument or verbal altercation that took place, and that the minor attacked her, and that she did defend herself only by holding the minor's hair to keep the minor from hitting her and striking her. My client reports that her father died when she was 1 year old, that her mother passed in 2021. And so she was living at this residence with her sibling, with her brother and her sister. She reports that she does not feel safe at that residence. She does not want to return to that residence. She has already identified another place where she can go with a friend who is with a family friend. She would ask for a one-time police escort to pick up the remainder of her belongings. She did get the majority of it the night of her arrest. She does not want any contact with anyone in that home, and we are requesting a signature on bond. Again, given my client's age and her financial position and the fact that she does not have any caregivers who can assist her with bond.
All right. Who is Terrence Cloud?
That is the minor's father.
Okay.
I'm sorry, my client's indicating that is not the child's father.
That is my brother, which is her nephew. I mean,
How old is Terrence?
40.
40.
Yes, ma'am.
Thank you. Okay, bond is going to be set at $3,000. It's going to be a signature bond through pretrial services. Is there any other adult relative who lives in that house other than Terrence Cloud? Who?
Yes, ma'am. It's also my sister, which is the minor's mother.
No, listen very carefully to the question. Is there any other adult relative? Not a minor, an adult. Terrence is 40 years old. Who else is an adult?
My sister.
How old is she?
She's 38.
How old is she?
38 years old.
38. That's Amaya Cloud?
No,
That, Amaya Cloud is the
I
minor.
know. What's his minor's name? Well, what's a 38-year-old's name?
Shantivia Cloud.
Shantivia Cloud.
Yes, that is her mother, my sister.
Shantivia Cloud is your mother?
No, ma'am, that is my sister.
Your sister, your older sister.
Yes, ma'am. Me,
Okay.
Shantivia, Terrence Cloud, Imaya, we all reside in the same household.
Well, not anymore. So,
Well, we all were residing in the same household.
and Miss Wills, you said you had an alternative address for Miss Denisha. Where would she be living?
Ms. Gantt was unable to provide the exact location. She did say that the friend's name is Genesis and she's either 25 or 26 years old, and that the law enforcement did arrange for her property to be taken to Ms. Genesis' address the night of her arrest.
Okay, I guess that would have to be taken care of. Bond is set at $3,000. Is a signature bond through pretrial services. And you said she's 18 years old?
Yes, Your Honor.
Okay, the signature bond has to be co-signed by either Shantavia Cloud or Terrence Cloud. Either one can go ahead and co-sign that bond.
Your Honor, I'm not sure that they would be willing, given the circumstances and what happened that
Well, I
night.
don't have a Genesis's full name. That's
I can use it Dozier or Dozier,
Dozier.
Yes, ma'am.
All right, and how do you spell Genesis? Genesis?
Yes, ma'am. Last name Doizer.
All right. If she is over the age of 21, then she can co-sign the bond. This is Genesis Dozier. Mr. Howard, the co-signer is Genesis, Genesis. Dozier, Dozier.
Who is this?
This is going to be her adult friend. And we'll need an address and we'll need an ID from Genesis Dozier before she can co-sign the bond. Ms. Gantt is to have no further contact with EC, the minor. She's to stay away from 28 Bowen Avenue in Atlanta, Georgia. She may return one time only with a police officer to retrieve her personal belongings. Within 30 days of being released, she must update the court with her new address, and she's not to consume any alcohol, no illegal drugs, and not possess any weapons or firearms. Her next court date will be sent to her new address. If she misses the next court date, a bench warrant will be issued for her arrest. Thank you.
So the cosigner is over 21?
I've been so informed. She's 25. So if she is not over 21, then she cannot co-sign.
This is per judge.
Yes.
Thank you, Judge.
Mhm.
Dawn, are you ready for courtroom 2?
Yes, I am.
Okay, this is position number 11, Ms. Taronda Oliver.
Okay. Rhonda Oliver is accused of battery domestic violence from May 18, 2023, accusation number 23CR003174J. Ms. Oliver, you've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod. Any priors, please?
First arrest.
All right. Mr. Jones, what's the recommendation?
Yes, Your Honor. The state's recommendation is going to be a $3,000 surety bond, a stay away from 979 Woodburn Drive, Southwest Atlanta, Georgia. A no further contact with Mary Tolbert. The reason for this recommendation is for the intimidation of a witness. Ms. Mary Tolbert, which is the victim, is the mother of the defendant, was struck in the face with a closed fist several times, causing physical harm, visible swelling to her right eye. We do not believe that there has been a fair enough cooling off period. Therefore, that is the reason why. And also the victim has stated that she does not want the defendant to return home, nor does she wants to have contact at the appropriate time if Your Honor can sound for the victim if she's on. Thank you.
All right. Mary Tolbert, if you're present, please unmute and start your video. All right, Ms. McLeod?
Hello.
I'm sorry, there she is. Okay, someone call Andre.
Yes, that's my daughter. I'm on her.
Okay, you need both to sit facing the window, the other way around. The window cannot be behind you because all I see is your silhouette. It's just a little photography thing I've learned from, very bad photographs.
Okay.
All right, now you can be seated.
Come on, keep it.
All right, who is Mary Tolbert?
I am.
All right, and Ms. Tolbert, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, Ms. Tolbert, what would you like to tell me?
I don't want her in jail, and I know she don't have no money. She's my grandbaby mama, and I want her with the baby. And she just recently started her job at the local hospital, and I want her to be able to go to work. The only thing I want her to do is move because she's not serving no financial help here or anything. I didn't even want her to go to jail, even though I didn't want her to be arrested. I know about this stuff, but I just that's my grandbaby, and that's my grandbaby mama, and I want her at home with him.
Where's the child? Where is the child?
He's here with his dad now.
And where would
you can hear him?
Does she have a place to go once she retrieves her child?
I don't know.
Okay, that's all I need to know. That's all I need to know. Thank you. You may mute your screen. Thank you, Ms. Tolbert. Ms. McLeod?
Yes, Your Honor. My client is 26 years old. As has been noted, she has no arrest record at all. She is gainfully employed as a CNA, she tells me.
Mm-hmm.
She is also the mother of an 8-month-old child. The complaining witness is the grandmother of the child. The father is the complaining witness's son, and they all live in the household. My client...
I'm sorry, so the biological father lives with the child as well in grandma's house?
The biological father is the complaining witness's son.
I see, okay.
Yes. And my client...
I will address you, Miss Oliver, you can put your hand down. Yes, go ahead, Ms. McLeod.
Well, Your Honor, she's never been arrested. We would ask for a signature bond so she can get out of jail. She doesn't really have anywhere else to go at this time, but I understand that the complaining witness does not wish to have her there. So we, of course, are going to be guided by what the court orders. She tells me that she does have some things for her baby, and of course her baby's there, so she's going to need to go back to get her baby.
All right.
Definitely ask for a signature bond so she can get out of jail and get on with her life and no further violent contact with the complaining witness, who is the mother of her child.
Unmute courtroom 2, please.
Good afternoon, Judge. How are you?
Good afternoon, Ms. Oliver. I've said it, I'm sure your attorney has said it. If you want to discuss your case or circumstances of your case in open court, anything you say can and will be used against you. If you waive your right to remain silent, you open the risk of being incriminated and making it very difficult for your attorney to represent you.
Ms. Oliver, unless this concerns your bond, I would advise you not to speak.
Okay.
Do you have anything to say at this time, Ms. Oliver?
I'll just take the advice of my attorney.
Okay. The bond is going to be set, it's going to be a $5,000 signature bond through pretrial services. No further contact with Mary Tolbert, and to stay away from 979 Woodburn Drive in Atlanta, Georgia. She may return one time only with a police officer to retrieve her belongings and her child. If the Ms. Oliver, and I'm sure your attorney has explained this to you, if you have your child outside of wedlock and the father has not filed a formal legitimation action in Superior Court, then the only person who has custody, full custody of the child is you. So you have the absolute right to remove your child when you go there for your one-time visit and pick up your belongings and your child. Do you understand?
Yes, Judge. May I just intercept a question, please? I understand that I was advised not to, but just for future references, how is it supposed to go about my son having his relationship with his father? Which we
Well, let me move on then.
okay.
As I was saying, no further contact with Mary Tolbert. And on your one-time visit, make sure you pick up your child and your belongings because you won't be allowed back there at all. Okay, until further order of the court. You're not to consume any illegal drugs. You're not to consume any alcohol and not possess any weapons or firearms. You're to report to pretrial once a month. And if you get arrested again, your bond will be canceled and converted to a $5,000 surety bond. That's why it's very important to comply with their conditions. While you are out on bond, also, you will attend and complete a one-day anger awareness program with pretrial services. Now, like I said, as long as if the child's born out of wedlock and the only thing the father has done is put his name on a birth certificate, then he has no custody and no visitation rights over the child. You have complete custody and rights over the child. Now, the father can still file a legitimation action with the Superior Court and get a court order to establish paternity and visitation and joint custody. And if he does that, then he'll be able to begin the process of, like you said, fostering a relationship with the child. Understood? Now, of course, daddy can always come visit you wherever you are living with the child. All right? But you cannot go to daddy as long as daddy's living with his mom. All right. Anything else, Ms. McLeod?
Nothing further, Your Honor. Thank you. And this concludes my business before the court today. May I be excused?
Yes, thank you. Have a great weekend.
Thank you, Judge.
Courtroom 2, you too, ma'am. Thank you. Next case, courtroom 2.
Next, we have position number 15, Ms. Sallard.
This is Eros Imani Salad, accused of battery, domestic violence on May 16, 2023. Her accusation number is 23 CR 003171E. Ms. Salad, you have been advised of your right to remain silent, and your attorney is Mr. Judd. Mr. Howard, any priors, please?
Second arrest, 2020, possession of a sawed-off shotgun, sale of marijuana, 2 counts, theft by receiving. That was dismissed.
All of the charges?
Yes.
All right. Mr. Jones, what's your recommendation?
Yes, Your Honor. So the state's recommendation is going to be a $3,000 surety bond, a stay away from 2456 Hardwood Drive, East Point, Georgia, and a no further contact with the victim, Mr. Lamar Scott. This is because the intimidation of witness, this was the defendant's boyfriend, and he was battered by the defendant. The defendant got upset after the victim did not want to see her new car. She then pushed him out of the side door, causing him to fall to the ground. The victim has expressed wanting contact and wanting the defendant to return. However, we are concerned about a sufficient cooling off period in the domestic violence cycle, Your Honor.
All right. What did you say, Lamar Scott?
Yes, Your Honor.
All right. And is Mr. Scott on the Zoom? Yes, he was. I believe he was.
Yes, I'm here.
There he is. Okay. All right. Mr. Scott, if you'd like to say something, I need to place you under oath.
Okay.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. I must say, this is one of the better photographs the Fulton County Jail has taken. So I compliment the staff at the Fulton County Jail. But Mr. Scott, what would you like to say?
I would just say, I would like to start off just by, just basing or talking about the incident. Really, it wasn't over the car. I believe it's because of she's dealing with a lot of stress. She does work 2 jobs. She does take care of her mother. She pays her mother bills. She's honestly been stepping up to the table so much that she has so much on her plate. She's just been so stressed out dealing with a lot, but at the same time, all of her goals, she's been accomplishing them. She's been knocking them out. she works very hard. You know, my God just said she just bought her first car the same day the incident happened. And I really, truly do believe that, you know, it wasn't aimed towards me. It was more, you know, the buildup of stress and you know, getting that release, because she has been through a lot. And, you know, she does feel like, you know, no one been there. It's very hard to take care of people at a very young age. You know, she works 2 jobs, you know, it's very hard. And, you know, that's just basically what I have to say. She's a great person. She's a great friend. She take care of this household. She has pets. You know, she also take care of her older siblings. She's the youngest, and she's always taking care of her family. Even when I first met her. So
Whose home is it?
I'm sorry.
Whose home is it? 2456.
This is our home.
Our meaning whom?
Me and Arrow Salad.
So both of you live there?
Yes, we rent.
Who else lives in the home?
No one. We have 3 pets. We have 2 dogs and 1 cat.
Who called the police?
I called the police. I called the police because you know, I'm a male for one, you know, and I don't want to see myself or her go to jail for one. I really called them because, you know, she already planned on, you know, leaving, going to her mom's house to stay and you know, take some break. But it was just more of the attitude, and you know, it didn't seem like it was de-escalating. So I called the
Sorry,
police.
but that response just doesn't answer my question. You called the police, right?
Because I wanted them to
You have the
know,
absolute
for
right to
protection.
call the police. And that's not my point, is asking you that question is not to question you on your motive. You have the absolute right. So I just want to be sure, under the circumstances, if you are the only 2 occupants, who else would have been there to have called the police? But it was you. Okay,
Right.
that's all I need to know. Thank you. All right, Mr. Judd?
Yes, good afternoon, Your Honor.
Good afternoon.
Your Honor, Miss Sallard, she has lived in Georgia her entire life. Your Honor, she has no prior similars, no violence, sexual or felonies on her history. I understand there is that 2020 charge that the state brought up. It's my understanding that that was dismissed, and according to Miss Sallard, it was expunged. But she may want to check on that if it still came up on a background check.
Expunge, we still do that?
It's rare that you hear about it, but I think so.
Go ahead, I understand. Go ahead.
Yes, Your Honor. Your Honor, the incident was at their place. However, if she is not allowed to go back to the location of 2456, she is able to live with her mother at 2266 Kennedy Court. Your Honor, so she does have an address, a stable address that she's able to go to. She may need to sort out financial issues with Mr. Scott. So if there is a no contact order of some sort, we would ask that it be no further violent contact, or that contact be limited through the phone, if need be, just so that she can work out her finances, Your Honor. We are asking that she be considered for a signature bond today.
All right. Bond is going to be set at $3,000. It's going to be a signature bond through pretrial services.
Thank you.
No further contact with Lamar Scott, with the exception of telephonic communication with regards to finances and arrangements with regards to household matters, since they both apparently rent from that facility. No illegal drugs, no alcohol, and definitely no weapons, no firearms, no sawed-off shotguns, nothing. If she is to stay away from 2456, what was that name? Hardwood Drive?
Hardwood, I believe, Your Honor.
Hardwood Drive? Yeah. And she may return one time only with a police officer to retrieve her personal belongings, including any pets that belong to her. If there's any dispute as to the ownership of any belongings, including the pets, she's to leave them there and resolve the ownership at a much later date, normally through a civil lawsuit.
Yes,
her next court date will be set to her at her new mailing address. She will be required to update the court with her new address within 30 days of being released. While she's out on a signature bond, she will also need to complete 4 anger management classes at her expense. She may begin those classes within 60 days of being released, and then she'll need to report to pretrial of the completion of the 4 anger management classes. Thank you.
Yes, Your Honor. And Your Honor, just for the record, Ms. Sallard did not qualify for our office's continued representation, so it was only for the purposes of bond today.
All right. Ms. Sallard, you will have to retain your own private counsel since you do not qualify for the services of the Public Defender's Office. So after being released and taking care of all these other matters, please also put finding an attorney as one more item on your to-do list. Thank you.
Thank you, Your Honor.
Go back to ACDC.
All right. Let me go. Okay. We are returning to State versus Brittany Jackson, 23 CR 002-791A. Ms. Jackson's been advised of, am I right? Is it?
Your Honor, this is Miss Tamaya Hayward.
Oh, I'm sorry. What? I thought we were dealing with bond for Ms. Jackson.
We did deal with that, Your Honor. You did rule on that, and I'll submit that order.
Oh, okay. I'm sorry. With Ms. Hayward. Oh, I'm sorry. Okay.
That's
Yeah,
okay, Your
just
Honor.
get me back on track. Sorry.
No,
Ms. Hayward, yes. We are returning to the non-negotiated plea hearing for Ms. Hayward. Yes. And what was your client's decision?
Your Honor, at this point in time, we would ask for a reset until next Tuesday to the SAP calendar. Your Honor, you will be on that calendar. We understand that you have ruled on the plea, but we would ask for the weekend since I didn't have adequate time due to the power outage. So we would ask for a weekend.
All right, we will reset it to May 23rd, SAP calendar at 9 a.m. Ms. Lewis, I guess we just get to keep the paperwork until 9 a.m. on Tuesday. Is that okay?
Well, no, not really, because of the fact that I have to do, we just sent out another add-on calendar, so that means I got to revise that calendar, and this is the weekend.
I'm so sorry, Miss Lewis. I promise you I'll get you a huge Kit Kat bar. Okay, thank you.
I will make it work.
right.
I just want people to be mindful there's going to be a revised or another add-on calendar, so people won't be saying I didn't get that calendar. So I just want to make that clear.
I'm sure Mr. Dotis won't object. And remember to share the Kit Kat bar with me too. Okay. All right. Thank you.
Thank you, Your Honor. And I believe that concludes my business, if I may be excused.
Yes, Ms. Dotis, have a great weekend. And think of Miss Lewis doing all this hard work for you.
I am always appreciative of
Well,
Ms.
if you don't
Lewis.
get the
Thank you
stuff to
both
me-
so much.
I appreciate if you get that stuff to me in a timely manner, even though I got to work tomorrow. So
I'm sorry.
Rubbing salt into the wound.
Your Honor, we have position number 5, Dr. Jai Dames.
All right, thank you. This is State versus Jai Jamis Dames, 23 CR 003-181D, accused of battery domestic violence on May 18th, 2023. Ms. Dames, you've been advised of your right to remain silent, and your attorney is going to be Mr. Judd. Your accusation number is 23 CR 003-181D. And Mr. Howard, any priors?
No.
Okay. Mr. Young, what is the recommendation?
Yes, Your Honor. The state's recommendation is a $2,500 surety bond, no further contact with the victim. Sinclair Dames, the spelling for the first name being Cinque. I probably mispronounced that. My apologies. Stay away from the incident location being 1345 Tahoe Pine Circle in Alpharetta. No alcohol, drugs, or weapons. 1-day anger awareness. Reason being that law enforcement responded to this location, spoke with the accused, the mother of the victim, who stated that she wanted the victim out and had admitted to hitting him. Spoke with the victim, who confirmed that he was struck by his mother. He's an adult. They noticed the mark on his wrist and a cut to his forehead. For those reasons, the state is asking for that bond.
All right. Did you say Cinque?
Yes, Your Honor.
Okay.
You would ask court to sample him when appropriate.
All right. Last time I pronounced that name was Cinque Dames. Are you present? All right, Mr. Judd.
Yes, Your Honor. Dr. Jai Dames is 51 years old. Your Honor, Dr. Dames is the one who called the police. She was the one who was initially grabbed. She was simply trying to get away. Your Honor, that is her house. She owns it outright. Her name is on the deed and everything. Her son does not live there. He has his own place where he lives that is not at the 1335 Tahoe Pine Circle address. Your Honor, she has no similar priors. It's my understanding that she has no criminal history of any kind. She has been in Georgia for 20 years. Your Honor, she has not only her undergrad degree, 3 masters, but also a PhD. She works for a nonprofit, Happy and Healthy People. She's also licensed with the federal government as a trauma specialist and anger management certified. Your Honor, she is the last person to do anything sort of violent. She's literally someone who provides anger management. She has family here in Georgia. She has a 24-year-old daughter who lives in Rex, Georgia, and a 22-year-old son out in Athens. She also has some cousins. Your Honor, we're asking that she be considered for a signature bond, and we would ask that there not be a stay-away order imposed since that is her home.
Bond is set at $2,000 as a signature bond through pretrial services. No further violent contact with Cinque Dance, and no illegal drugs, no alcohol, no weapons, and no firearms. If she owns any firearms, they have to be removed from the home and surrendered to authorities for destruction. Her next court date will be sent to her at the Tahoe Pine Circle location. Thank you. And I may be speaking ahead of time, but Dr. Dames, you would have to retain counsel as the Public Defender's Office will be recusing themselves. Thank you.
Next, Your Honor, we have position number 16, Mr. Marcus Sims.
This is accusation number 23 CR 003170B. State versus Marcus Sims, accused of simple battery against a police officer and willful obstruction of an officer from May 10th, 2023. Mr. Sims, you've been advised of your right to remain silent, and your attorney is going to be Mr. Judd. Mr. Howard, any priors?
34 total. He was arrested this year for a felony obstruction, simple assault. He got a probation violation from last year, 2 from 2021. 2021 battery DV, 2020 giving false name, no load. 3 probation violations from 2020, 1 from 2018, 2019 trespass, no load.
That's good, thank you. Mr. Young or anyone from the state? Oh, yes.
Yeah, Your Honor, I believe this is a case that's being handled by ASG Jones, but I do not see him on the Zoom
I'm
call.
here, Your Honor. Good afternoon.
Good afternoon, Mr. Walker. Yes, sir.
So Mr. Jones' Wi-Fi just went out, so if you could just bear with me momentarily, I will be glad to present on behalf of the state. I'm pulling it up as we speak. I'm sorry, what is the defendant's name?
Marcus Sims, position number 16. He's accused of simple battery against an officer and willful obstruction of an officer, and the report indicates 34 cycles on his record.
Okay, I'm getting the notes on him pulled up as we speak. Just 1 second, please.
And I understand this to be a detention incident, so.
Okay, if the defense would like to go first, that's okay, if the court will allow it, as I'm trying to pull up Mr. Jones's notes.
Mr. Judd, grab this opportunity.
Yes, Your Honor. Would it be possible to first present my case and then possibly respond? Because I'm not sure what the state's going to bring up.
Okay, and I've been told that Mr. Jones is in the waiting room if he can be brought in.
I let him in. It's apparently he's taking time to get in with his Wi-Fi.
Okay.
Yeah. Go ahead, Mr. Judd. You can present and you will get a chance to counter.
Thank you, Your Honor. Your Honor, Mr. Marcus Sims has lived in Georgia his entire life. He didn't finish high school through Georgia, but he did get his GED while he lives here, excuse me. He does have some family here, both his sister, his brother, and his mother. Your Honor, I understand that there are some priors and probation violations from what was said earlier. It's my understanding he doesn't have any failure to appears, unless I missed that being said by pretrial, which is possible, Your Honor. It's my understanding that this is based simply off of something that happened while he was already in custody, that he had allegedly thrown a plastic tray that hit one of the security guards in the leg. And Your Honor, he was, if that even happened, he was met by being tased in the back. I would ask that be considered punishment enough, seeing as that seems to be a higher response than what was really called for, and ask that he not be made to make any additional bond on top of what he already has to make for his other charges. And Your Honor, I would assume, but I don't want to assume, that we are only handling that incident and that we're not handling the felony issues.
I'm not sure, but no, I'm not handling felony issues. I
Understood.
think I can, but so what are you recommending in terms of his bond? It's presently set at no bond.
Your Honor, we would ask that be set to a signature bond. He already has a very high bond set on his the charge that currently has him locked up in Rice Street.
Okay.
He did want me to try and address that bond, but it's my understanding that that's not really our our wheelhouse here.
Okay. Mr. Jones, you're back. Would you like to pick up as to what the state recommends for bond?
I can take it, Your Honor. So for Mr. Sims, we're recommending a $2,500 surety bond on the simple battery against a police officer and a $1,000 surety bond on the obstruction. In this case, I'm sure the court has reviewed the warrant, but as you're aware, he was pleasing himself, you will, in front of a detention officer. She requested that he stop. He, at that time, became angry, apparently threw a tray and hit her in the leg. And at that time, he did resist being restrained. I understand that he does have a 2018 civil battery conviction, so we are requesting a $3,500 total surety bond. No further, I don't know if we could do a no further contact since he is incarcerated, but we will be asking for a no further violent contact with Detention Officer Jenkins and Detention Officer Harrison. Thank you.
And Mr. Judge, did you have anything else to add?
Yes, Your Honor. There was things that I wasn't sure if they were going to come out, but they did. So, Your Honor, Mr. Sims does deny having been masturbating in the jail. He did have his blanket over him. He was eating his food. He says that that's not something he normally does while he eats, and that he was simply trying to give the tray to the officer because he was done with his food, that there was no intentional assault or battery, that he wasn't throwing the tray at her or at the officer. He was simply trying to give the officer his tray. And like I said before, it was met with a taser to the back. He already has a $12,000 bond on the charge that's keeping him in. We would ask that there not be anything further added on to that, since he clearly can't even make the $12,000 bond, Your Honor.
All right, thank you. On the simple battery is going to be $1,000 surety. On the obstruction is going to be a $1,000 signature bond through the jail. That's a $2,000 split. His next court date is going to be June 1st, 2023 at 9 a.m. the SAP calendar. No alcohol, no illegal drugs, and no weapons. And no violent contact with Officers Jenkins, Officer Harrison, and any other staff member at the Fulton County Rice Street Jail. Thank you. His other case is 23 CP 216869. That is a Fulton County Superior Court case. We are in state court right now, so we do not have the subject matter jurisdiction to address that case. That would have to be handled by a separate judge. Thank you.
Yes, Your Honor. Thank you.
Next, we have position number 1, Mr. Baker.
This is State versus Jacques Baker, 23 CR 003-179F. Mr. Baker is accused of battery, domestic violence, and 2 counts of cruelty in the 3rd degree from May 17th, 2023. Mr. Baker, you've been advised of your right to remain silent. Your attorney is going to be Ms. Wills. Any priors, Mr. Howard?
Ninth arrest, 2022 arrest out of Florida, simple assault, battery, touch or strike, that was dismissed. 2012 probation, 2012 culpable negligence inflicts injury and fleeing an officer conviction.
Mr. Jones?
Yes, Your Honor, I do apologize about that.
No apology required.
The state's recommendation is going to be a $3,000 for the battery and $1,000 on each cruelty to children charge for a total of $5,000 surety bond. The reason for the state's recommendation is for an intimidation of witness. This was the defendant's girlfriend, in which he grabbed her by the face and slammed her head into a wall. As a result, she received lacerations on her head. This happened in front of their two children, one of them age 5 and the other one under 18. In fact, the officer noticed that while the victim was trying to tell the officer what happened, the defendant tried to control the victim by not allowing her to speak. While the victim does tell the office she wants contact with the defendant and is not in fear of her life, we are concerned about a sufficient cooling off period. Also, we believe that the defendant is a danger to the community. The defendant recently received a medical diagnosis that requires him to take medication. And according to himself and his wife, he is refusing to take that medication. For those purposes, we are requesting a $5,000 surety bond. Again, that's $3,000 on the battery and $1,000 on each cruelty to children's charge. Thank you.
Okay. And this is his spouse, I understand.
Yes, his spouse name is Sparkle Baker.
Yeah. All right. Mr. Baker, I'll be glad to let you speak, but your attorney is going to speak on your behalf first. So you will wait for her to speak first, and then you think about your right to remain silent and if you want to waive that. Ms. Wills?
Thank you, Your Honor. And I would ask that the court sound for Ms. Baker. I did speak with her prior to court, and she indicated that she would be joining the Zoom call.
Okay. Ms. Sparkle Baker.
Yes, I'm on the call, but I had to take it from my phone now because I'm late getting one of my kids from school, but I'm here.
Are you driving?
I just stopped at a light.
Then I'm going to remove you from Zoom until you stop driving. And
I can pull over. No. I can pull over. I can pull over. I put my hazards on. It's fine. Please, I've been waiting on a call for the whole time. Oh, okay, video. Let me get to a safe spot to pull my car over. Can you see me?
You need to open your car door.
Open my door, all right.
Your side of the door, which is on your left-hand side.
Yeah, I know, but where I was is here, so I need to pull up a little bit further before I can.
Please remove her from Zoom. And let us know when you parked.
Okay, give me a second, thanks.
All right, Ms. Lewis, please remove her. Thank you. All right, Ms. Wills, you may proceed.
Thank you, Your Honor. My client is 40 years old. He recently relocated back here to Georgia with his wife and children, but they did live here previously. As was stated, he is married to the alleged victim, Ms. Baker. In this case, they have 3 children together, well, 3 minor children together. My client is currently a writer and actor, but he is also a veteran of the Navy, and he does receive a disability. My client indicates that on the day of this incident, or when this occurred, it was the alleged victim who became aggressive toward him, that he did defend himself, that he received several injuries as a result of the alleged victim's actions on that given night. After he and Ms. Baker spoke, the situation did de-escalate. However, unbeknownst to my client, his daughter, who is 22 years old, who also lives in the home, called law enforcement, and then law enforcement arrived, and my client subsequently was arrested as a result. I am asking for a signature on bond in this case, Your Honor. I see Ms. Baker is back. I did have the opportunity to speak with her, and she would request no further violent contact between herself and Mr. Baker. Thank you.
All right, thank you. Ms. Baker, are you parked now?
I'm parked. I'm scared to open the door. If you can see cars are going past me though.
Okay. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, and what would you like to tell us?
I wasn't planning on speaking today. I just don't want any violent contact. That's
Okay.
it.
All right, thank you.
You're welcome.
On the battery domestic violence, that's going to be a $2,000 surety bond. On each of the cruelty charges, that's going to be $750. That's a total of $3,500 surety bond. No further contact with Sparkle Baker. I'll allow for a third-party transfer of the children, which means that he can see the children as long as there's a third party to pick up or and transport any minor children that they both share. He is to stay away from 3794 Lake Haven Way in East Point, Georgia. He may return one time only with a police officer to retrieve his personal belongings. Within 30 days of being released from jail, he must update the court with his new mailing address.
Your Honor. I'm sorry. We're the only ones here in Georgia.
So I guess he'll be home shopping.
I'm the primary caretaker for the household. He's been a stay-at-home parent. So
Ms. Baker, you're going to have to make alternative arrangements. Thank you. As I was saying, Mr. Baker will have to reside in a separate location until further order of the court. No further contact, Mr. Baker, means you have to stay 200 yards away from Sparkle Baker. You're not to communicate with her in any way, form, or manner, including in person, a phone, a computer, social media, or through third party. The only communication you can have through a third party is regarding visitation and custody of the minor children that you share with her. If you violate the conditions of the bond, you could be arrested and charged with a felony count of aggravated stalking, which constitutes a violation of a court order. And that could end up being in a no bond status for up to 3 months. Your next court date is going to be June 1st. If you do make bond and are released on bond, please be sure to update us with your new mailing address, and you will not have to show up for the June 1st calendar. All right. Sergeant Norrison, does Mr. Baker have something to say?
Yeah, he said he didn't really understand everything you said.
Which part did he not understand?
What's a surety bond?
A surety bond is a bond in which you would have to pay a portion, if not all of it, in order to be released from jail. You can go through a bonding company and they charge a percentage of the bond amount, and it's typically between 10 to 15% of the total bond amount. Once you make bond through a bonding company, you'll be released, and then you need to comply with the conditions of the bond. Anything else?
No.
All right, thank you. Next court date is June 1st, unless he is released on bond. Thank you.
Next, Your Honor, we have position number 2, Mr. Darius Campbell.
All right. Mr. Darius Campbell, 23 CR 003180F, is accused of battery, domestic violence, cruelty in the 3rd degree, and hindering a person from making an emergency phone call from a May 18th, 2023 incident. Mr. Campbell, you've been advised of your right to remain silent, and your attorney is Mr. Judd. Any priors, Mr. Tucson, Howard?
No.
Okay. Mr. Young?
Yes, Your Honor. This incident occurred on May 18th, 2023 at 1400 Building J, I believe, Riverwood Lane in Rossville, Georgia. Law enforcement arrived at this location. They immediately noticed a bite mark on the arm of the victim. This Aris Johnson. We would ask the court to sound for her when appropriate. They also observed a bruising on her knee. She told the officer that her boyfriend, the defendant, got agitated with her daughter for writing on the wall. He then grabbed the victim, throwing her into a television. And at some point during the physical altercation, he bit her. They have only been living together 3 months, and the child was present in the home when all of this occurred. and there has not been an adequate cooling off period. So for that, the state recommends a $4,500 surety bond. There's $1,000 on the cruelty, $1,000 on the hindering, $2,500 for the battery family violence, no further contact with the victim, and stay away from the incident location.
All right. Ms. Eris Johnson, are you present? This will be the time to speak up. All right, Mr. Judd?
Yes, Your Honor. Mr. Campbell is 20 years old, and he's lived in Georgia his entire life. He is a graduate of Douglas County High School. Most of his family lives here. His grandparents, his siblings, his cousins are all living in Georgia. Your Honor, he has no similar priors, no felonies, no violent history or sexual crimes. It's my understanding he has no history of any kind, and thus no failure to appears. Your Honor, Mr. Campbell does maintain that that the complaining witness was the initial aggressor. Your Honor, he is okay with a stay away order. He is okay with a no further contact order. While he does currently live at the 1400 Riverwood Lane, he is able to go and live with either his sister or his cousins, all of whom live in Georgia. So, Your Honor, he has no issue with those conditions. He has been dealing with a few issues. Back in January of this year, his 5-month-old daughter passed away. Your Honor, we would be asking that he be considered for a signature bond. And also for the record, Mr. Campbell does not qualify for the continued use of our office's services.
All right, thank you. On the battery, it's going to be $3,000. And on the cruelty and the hindering a person, it's going to be $1,000 each. That's a $5,000 signature bond through pretrial services. No illegal drugs, no weapons, firearms, and no alcohol. Mr. Campbell is to have no further contact with Eris Johnson. I want to make sure I'm pronouncing as AYRESS Johnson and her minor child or children. He's to stay away from 1400 Riverwood Lane in Roswell, Georgia, in Fulton County, and that would be the entire complex, the entire apartment complex. He is not to return to that property, even to retrieve his belongings. Ms. Johnson may make arrangements with a third party for Mr. Campbell to pick up his belongings. But when he can pick up his belongings at a police station or a designated area where Ms. Johnson will put his belongings, but he is not to return to that property. His next court date will be sent to him, so he needs to update us with his new mailing address within 30 days of being released. He will report to pretrial once a month, and while he is out on bond, he will attend and complete 12 anger management classes at his expense. Those classes must begin within 60 days of release. And Mr. Campbell, upon being released, you would also have to retain your own private counsel because you do not qualify for the public defender's office. Thank you.
Thank you, Your Honor.
Next, Your Honor, we have position number 6, Mr. Trayvon Dixon.
Mr. Dixon, first name Trayvon, is case number 23 CR 003175E, arrested on an incident from May 18, 2023. He's now been accused of battery against an individual who's pregnant, cruelty in the 3rd degree, and simple battery family violence. Mr. Dixon, you've been advised of your right to remain silent, and your attorney is Ms. Wills. Mr. Howard, any priors?
4th adult arrest. 2019 probation, and he on probation in Douglas County. 3 counts of theft by taking, 2 counts of burglary. That's it.
Thank you. Mr. Jones?
Yes, Your Honor. So the state's recommendation is going to be on count 1, battery against a female pregnant is going to be $3,500 surety bond. Cruelty to children is $1,000 surety bond, and simple battery is going to be a $1,500 surety bond. for a total of a $6,000 surety bond. The reason for the state's recommendation, Your Honor, is we believe that there's a grave risk of intimidation of the witness. This was the defendant's girlfriend, and while feeding their 8-month-old son, the defendant became irate over something in the victim's phone. While seated on the bed, the suspect struck her with a closed fist to the face 2 to 3 times. In fear, the victim stood up to defend herself. The victim sustained a laceration to her upper and bottom lip and bruising to the left side of her face near her chin. Also, in this instance, the officer did notice that prior to speaking to the victim, the defendant tried to control the victim by not allowing her to speak. The victim is 3 to 4 months pregnant. The victim believes her lip will need stitches, and this is not the first time the defendant has been violent with her. She is currently in fear for her life and does not want the defendant to return to the property. Also, we noted a probation violation of 2019. And in addition, the defendant is currently on an active probation right now, Your Honor. For those reasons, that's why we request the $6,000 surety bond. And if the victim happens to be on, we will ask for the court to sound for her at the appropriate time. Thank you.
All right. Tanisha Brinson. Tanisha Brinson. All right. Ms. Wills.
Thank you, Judge. My client is 22 years old. He is originally from Georgia. He has obtained his GED, as it was stated. He and the alleged victim do share an 8-month-old child. And my client reports that he is currently employed with Rebar of Georgia, and he does construction work with them. And he has been employed there for the past 3 months, and he will not qualify for our services. My client does deny the allegations as alleged. However, he will be moving out, and he does have alternative housing. So we would ask for a one-time police escort for him to pick up his belongings. And he will update the court within 30 days of his alternate or new address. And we have no objection to no further contact with the victim at this time. And we would also ask for third-party visitation for the minor child that they share.
All right. On the battery against the female who's pregnant, that's a $3,000 surety bond. On the cruelty and the simple battery family violence, that's going to be $1,000 each. Total bond is set at $5,000. That's a surety bond. No further contact with Tanisha Brinson. No further contact with any minor children that Ms. Brinson has. Any contact that he wants with the child that he shares with Ms. Brinson must be established through a legitimation court order. No alcohol, no drugs, no weapons, and his next court date is June 1st. Thank you.
Next, Your Honor, we have position number 8, Mr. Mackay Grant.
Okay. With regards to Mr. Dixon, there is no return to the property, not even that one-time visit. Ms. Brinson can arrange for his items to be dropped off at a mutually convenient place. Okay, we have, is this Marky Grant?
Mackay Grant.
All right. Accused of simple battery domestic violence on May 18th, 2023, case number 23CR 003176G. Mr. Grant, you have one count of simple battery domestic violence. And Mr. Howard, any priors?
Second arrest. He was arrested in March. Possession of cocaine, sale of marijuana, possession of a firearm during the commission, and possession of a firearm by a person under 18 years of age out of Athens, Clark County.
Thank you. Mr. Jones?
Yes, Your Honor. So the state's recommendation is going to be a $3,500 surety bond for the following reasons. A, the intimidation of witness. The victim here is the defendant's older brother, and he was struck in the mouth with a closed fist several times. We do not believe that there has been an adequate cooling off period. In fact, we also believe that the defendant is a danger to the community. As the court just heard, just 2 months ago, the defendant picked up very serious charges, including possession of a firearm by someone under the age of 18. And just 2 months later, the defendant is back involved in trouble. The defendant, we did have a chance to speak with the defendant's mother and the victim here. The mother does not want the defendant to return back and does not want any further contact with the defendant. At this point, we are definitely concerned about him being a flight risk with that. The mother said that she doesn't believe he has anywhere to go. So, Your Honor, we are gravely concerned for those following reasons. Thank you.
All right. Mr. Judd?
Yes, Your Honor. Mr. Grant is 17 years old. Your Honor, he maintains that his older brother is the one who threw the first punch. As someone who has a younger brother with only a few years difference, I can tell you that, I mean, brothers do get into fights. But he does maintain that the older brother was the initial aggressor in this case. He does maintain that he has a place he can live that is with his grandmother out in Athens, so still in Georgia. We don't believe him to be a flight risk because Georgia is all he knows. He's lived in Georgia his entire life. He was born in Athens. He attended Clark Central High School in Athens. While he didn't graduate, he is currently working on his GED. Your Honor, it's my understanding that as far as his history, there's no prior violence or felonies or sexual crimes, no failure to appears. He does have family in Georgia other than the one brother involved. You know, he has his grandmother. He has 3 other brothers here, 2 aunts, 2 uncles, a few cousins. He is okay with a stay away order, but he would need a visit with along with a Fulton County sheriff in order to pick up some of his belongings. And he's okay with a no further violent contact with his brother, though if necessary, I did tell him that it would likely be a no further contact with his brother.
Okay, thank you. I see Ms. Sharmikia Grant present on the Zoom. You would need to unmute your screen, Ms. Grant, in order to be heard.
Hello?
Yes, I can hear you. Are you
Yes, ma'am.
Sharmikia Grant?
Yes, ma'am.
Please raise your right hand.
Okay.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
I'm not gonna waste much of your time. I see you got a lot going on, but just to sum it all up, my son is not a bad kid. I know that he caught those charges a couple months ago. I think that he felt for his safety. To sum it all up, I feel partially responsible for the way that my son is now because he's been had issues. Like he was writing upside down and backwards and behavior issues in elementary school. I tried to get him help and I was turned away because I had Medicaid and his dad had his insurance on him and wouldn't sign because he was the policy holder. I knew I had been warned about this would be the outcome. I've known this. He's been doing this all his life. But the thing is, he's gotten older now and he's more stronger. And he thinks that is something wrong because my mom and his dad has got him thinking that mental health is something that is you have to be ashamed of, you know, something that is not, oh, you'll grow out of it. You know, it's nothing. Like my baby is really hurting. My baby needs help. I don't want him locked up. He has so much rage to me that he cannot be at my home because I got a 2-year-old baby. And my baby needs help. He needs help. Like really, he's a smart kid, and even though he had those problems in school, he was still smart. And he can, if you listen to him talk, he can express words, he can use words, you know. But I don't want him locked up.
Miss Grant, does Calvion still live with you?
Yes.
Okay, thank you. You may mute your screen, please.
Yes.
Thank you. Bond is going to be set at $4,000. It's going to be a surety bond. No further contact with Calvion Edwards and needs to stay away from 1838 Honeysuckle Lane in Atlanta, Georgia. No illegal drugs and no weapons. Next court date is June 1st.
And Your Honor, would he be allowed one visit with the sheriffs to pick up his belongings?
Yes, one-time visit with a police officer to retrieve his belongings, yes.
Thank you, Your Honor.
Who do we have, please? Is this Rico Leak? Officer? Deputy, is that?
I'm sorry, Your Honor. I'm sorry.
That's okay.
Mr. Leak is going to be a medical reset.
Okay.
And this is position number 12, Mr. William Owens.
Okay.
Mr. Leak, I filed a waiver and I had requested a breakout room for Leak and Sailor through Miss Lewis.
Okay, remind us as we get towards the tail end of the calendar then, okay?
Yes, Judge.
Thank you. Now we have Mr. Owen, which is position 12. Any announcement on Jashawn Lowry?
Your Honor, he was in court yesterday. They actually did his cases yesterday. I think he was just put on the calendar by accident.
Okay, just wanted to be sure. Thank you.
You're welcome.
Mr. William Owens is case number 23 CR 003183G, accused of public drunk and violations of the rules regarding pedestrian and roadway. This is from a May 18th, 2023 incident. Mr. Owens, you've been advised of your right to remain silent, and your attorney is Mr. Judd. Mr. Young, what's your recommendation? Oh, sorry, Mr. Howard, any priors?
11 total, 2020 DUI, hit and run, fleeing an officer. That was a conviction. And before that was a 1997 arrest.
All right, thank you. Mr. Young?
Yes, Your Honor. This incident occurred on Pine Grove Road in Roswell at the 470 block. Law enforcement were dispatched to this location in reference to a person stumbling and falling in the roadway, causing vehicles to have to go around. Law enforcement made contact with the defendant, who admitted to drinking some beer, asked why not take the sidewalk, and he stated that he'd rather walk in the middle of the roadway. So the state's recommendation is to go with the preset $1,000 surety bond. I think that is for the public drunk, and for the pedestrian and roadway, there's an unsecured pretrial. There's like an unsecured judicial release for the pedestrian and roadway, and no alcohol, drugs, or weapons while on bond, and alcohol, drug evaluation treatment.
All right, thank you. Mr. Judd, I understand your client has a Superior Court hold as well.
That's correct, Your Honor.
And a Sandy Springs hold.
I was unaware of that, Your Honor.
Okay, go ahead with, do you have any objection to the bond recommendations by the state?
Your Honor, I believe the recommendation was for a surety bond, so we would be asking for a signature bond in his case.
Okay. Just, let me see. I have a Sandy Springs hold. I do not know for what offense. Then I've also got a Superior Court hold. The case, I wish. (23 CP 218617). Bond is set at $1,000 a surety on the public drunk, and pedestrian roadway is going to be a $500 signature bond through the jail. Total bond is a $1,500 split bond.
And Your Honor, I was hoping to make bond arguments.
Oh, sorry. Go ahead. I thought you were done.
No, Your Honor. Your Honor, Mr. Owens has lived in Georgia for 20 years. He doesn't have any family. The ones that he knew have all pretty much passed away. He is a veteran of the Army. He served for 4 years, honorable discharge. He had 2 tours, one in Panama, one in Afghanistan. It is my understanding that he had just gotten done with the job. His phone went dead. He was walking to where he was staying, and that he was not walking in the middle of the road, as in walking up the middle of the road. He was walking along the side of the road, and he got to a point to where that side of the road became dangerous. The other side of the road was more open and thus safer to walk, and he was crossing the road. That's my understanding from Mr. Owens. Okay. So we would be asking for a signature bond on his case, Your Honor.
All right. Those are going to be issues that you're going to have to take up at a hearing with the officer present. I'm just going to go by the warrant, and I'm still comfortable with the bond amount I set. Thank you.
Your Honor, he actually went to felony court earlier today and got a $12,000 good bond.
Okay, so this means he'll have a total of a $13,500 good. Sorry, $13,000 good bond plus a $500 signature bond through the jail. Thank you.
Yes, Your
And
Honor.
condition is just no alcohol.
Yes, Your Honor.
Next, we have position number 13, Mr. Bishop Roland.
Okay, Ms. Grant, I will address your question shortly. Let's address Bishop Roland, 23 CR 0031173Y. Mr. Roland's accused of battery, domestic violence from an April 10th, 2023 incident. Ms. Roland, you've been advised of your right to remain silent, and your attorney is Ms. Wills. Any priors, Mr. Howard?
Fourth arrest. Last arrest was back in October, suspended license. On probation for that. 2018 simple battery conviction. 2014 suspended license for dismissal.
Thank you. Mr. Jones?
Yes, Your Honor. So the state's recommendation is going to be a $3,500 surety bond, stay away from 2649 Hightower Court, Northwest Atlanta, Georgia, and no further contact with Ms. Crystal Roland. The reason for this is the state is concerned for the intimidation of witness. This was the defendant's girlfriend, and she was assaulted by her child's father. The defendant got upset after the victim asked for a house key, and then he proceeded by throwing a bottle at the victim's head, slapping her across the face, and pushing her to the ground, resulting in cuts. Your Honor, we do not believe that there has been a fair cooling off period. Also, the defendant fled the scene with his mother, so we are concerned with his ties to the community, as the mother did take him away from the house. Also, the danger to the community. As you heard, the defendant has a previous simple battery conviction in 2018 with another young lady, Your Honor. So for those reasons, that's why the state is asking for the $3,500 surety bond, stay away from the incident location, and no further contact. Thank you.
I see a Crystal Roland on the Zoom. Would you like to be heard?
Yes, Judge.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Yes, what would you like to tell us?
That I'm okay with him returning home to 2649 Hightower Court, and that I do not feel fear for my life, or I'm not in danger.
And why is that?
Because the argument just got a little bit heated, and it just escalated, and I had part in that.
Okay. And Mr. Howard, do you know anything about this Douglasville hold? He's got a probation violation. Is that for the
That's probably traffic. If it's probation, it's probably for traffic.
Traffic. Is that the suspended license?
Correct.
Okay. All right.
I'll have to look it up.
Ms. Wills?
Thank you, Your Honor. My client is 30 years old. He has resided in the state of Georgia for the past 14 to 15 years. He has 3 years of college. He is currently unemployed, unfortunately. My client reports that it was the alleged victim, Ms. Roland, who actually instigated the physical contact between the two of them, that she actually made contact with him by stabbing him with a knife, or at least jutting him, hitting him, striking him with a knife, and then threw a knife at my client. Mr. Roland states that he defended himself, and that Ms. Roland also tried to pull his hair out during the altercation. My client states that his mother was present when all of this occurred, that she witnessed everything, and that he left not to flee, but to cool off after the situation had escalated to that point. My client reports that he did not know he had a warrant for a significant amount of time. Again, this happened in April, on April 10th of this year. My client reports that his father recently passed away, and he passed away shortly after this incident, which is what caused him to violate his probation. He was actually out of town and missed his court date because he was gone for his father's funeral. I would ask for a signature on bond, Your Honor. As my client does not have a job currently, he states that nothing like this has ever happened between himself and Ms. Roland. And if Your Honor is not so inclined, I would ask for a $750 surety bond and ask for no further violent contact between my client and Ms. Roland per her request.
So, I mean, I'm just trying to reconcile this with what Crystal Roland just said. So based on what Miss Roland said, she said it was just a tussle. But now there are allegations that she allegedly stabbed him with a knife, which is a aggravated assault or aggravated battery felony charge against her, if that's the case. And that she pulled his hair, which would then be a simple battery charge against Miss Roland, if that's the case. And if that's a situation, then I guess, Miss Roland, do you have any comment about that? Because this is all on Zoom being recorded and the prosecutor's hearing all this. So you're telling me now that you're comfortable with him coming back to you and you possibly facing felony charges?
I am comfortable with him coming back, and I did not.
Miss Roland, let me go a step back.
Okay.
They are saying in the presence of this Zoom recording, with his mother being present, that you allegedly stabbed him with a knife and pulled his hair.
Well,
and so are you telling me under oath that that's what happened?
I did not stab him, no.
Did you pull his hair?
I did, but that was during the altercation.
Did you instigate pulling his hair?
It was after the beer can was thrown in my face.
And who threw the beer can at your face?
Mr. Roland.
All right. And so now you want me to let an individual who's claiming that you feloniously assaulted him with a knife to let him back into the same home with you? Thank you, Miss Roland. You may mute your screen. On the battery domestic violence, it's going to be a $5,000 surety bond. No further contact with Crystal Roland, to stay away from 2649 Hightower Court. And upon release, he's not allowed to return to 2649 Hightower Court, and he's not allowed a one-time visit. If there are any belongings that reside at that location, Miss Crystal Roland can go ahead and make sure that those items are available for his pickup through a third party. If they share any children, I will allow for third-party transfer of the children. No illegal drugs, no alcohol, and no weapons. Thank you. Next court date is June 1st. Ms. Crystal Roland, I highly recommend that you speak to the Victim Advocate's office at the Solicitor General's office to go over this case and make sure that you don't subject yourself to being charged with any crimes. Thank you.
I'm sorry, we got position number 17, Mr. Omarion Taylor.
Okay. Do you know what's the situation with position 14, Elsa Saylor?
That's the other case.
Oh, yeah, that was your other waive appearance. Okay, thank you. All right, Mr. Omarion Taylor is case number 23 CR 0031698H. He's been accused of simple assault, domestic violence from May 18th, 2023. Mr. Taylor, your attorney is going to be Mr. Judd, and you have been advised of your right to remain silent. Mr. Howard?
Fourth arrest, 2016 probation, 2014 disorderly conduct conviction, and a 2013 CWAC first offender.
Oh, thank you. And what was the CWAC charge? What year?
2013.
2013. Thank you. 1996. Okay. Yes, Mr. Young, what's your recommendation for Mr. Taylor?
Yes, Your Honor. The recommendation is a $2,500 surety bond. No further contact with the victim, Nakisha Jordan, who was also on the Zoom call. stay away from 86 Vine Street in Atlanta, and 1 day anger awareness, no alcohol, drugs, or weapons while on bond. She told law enforcement when responding to this location that she was headbutted by the defendant, who is her live-in boyfriend.
Okay. And I'm sorry, what was that recommendation again for the amount?
$2,500.
2,500, okay. I don't know why I wrote down 3. Okay, 2,500. All right. Okay, Mr. Judd?
Yes, Your Honor. Mr. Taylor is 26 years old. He does maintain that things never got physical, that he had never touched the complaining witness. Your Honor, he has lived in Georgia his entire life. He attended John McElrick High School. He didn't graduate, but did get his GED. He does live with his girlfriend there at the Vine Street address. However, after speaking with him, I believe he is able to live with his mother at 500 McDaniel Street, which is actually the address that's on the booking report. So that is still a good address for him. He is able to live there if there is a stay away order put in place. Your Honor, with talking to him, it was my understanding that there were no felonies, no violent crimes, no drugs, no FTAs. He has several family that live here, his mother, his children, his aunt, his cousins, his brother, his sister. So he does have a very strong tie to the community. We don't believe he's likely to reoffend. We would be asking that he be considered for a signature bond. And Your Honor, we would ask for the no contact order to be no further violent contact, since they do share a child together. Though if not, then at least allow a third person transfer of the child.
Your Honor, if I may briefly, our office did speak with Ms. Jordan, and she said that she is not in fear. She's okay with contact, but however, the state is concerned because she said that there has been violence before between the two. So that is a concern for the state.
All right.
However, she is on the Zoom. Maybe she can elaborate.
Is she NJ? Is that her identity?
I believe so. That's the initials for Nakisha Jordan.
Nakisha Jordan? If you want to address the court, this is the time to do so. You need to unmute and start your video. Can't hear you.
Okay, there we go. Yes.
If you need to raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Right. So, Ms. Jordan, the warrant says that Mr. Taylor, allegedly under the influence of drugs and alcohol, apparently headbutted you.
Yes, he did.
Okay. And what else would you like to tell me?
Omarion has an alcohol problem. When he's not drinking, he's perfect. But when he is,
how do you feel about having contact with him?
I don't mind having contact with him. I feel like he needs help with his alcohol and drug addiction. I feel like
and if he doesn't get help with his alcohol and addiction, how do you feel about contact with him?
I don't think that'd be a good idea.
Okay, that's all I needed to know. Thank you.
All right.
All right, bond is going to be set at $1,000. It's going to be a surety bond. No further contact with Lakeisha Jordan. No illegal drugs, no alcohol, and no weapons. And while Mr. Taylor is released on bond, he is to undertake an alcohol and drug evaluation within 60 days of being released and report his appointment to the solicitor's office that he has got an alcohol and drug evaluation, and he must submit himself to any treatment if required at his expense. Thank you. Next court date is June 1st.
And Your Honor, two things to address on that. Mr. Taylor he does not qualify for continued use of the public defender's office. So he will need to get a private attorney. I've already spoken with him about that. And since Your Honor put in place a no further contact, would he be allowed a third party transfer to see his child?
Yeah, well, because of the alcohol and drug issues, I'm going to allow him to have contact once he files a legitimation action and gets a court order to establish visitation and custody.
Yes.
Of course, there must be proof also that he is taken an alcohol and drug evaluation and submitted himself to any treatment as required. Next court date is June 1st. And Mr. Taylor, you probably need to retain private counsel once you're released on bond. Thank you.
Your Honor,
Yes, Counsel.
the possession and use of drug-related objects, was that NOD?
That was NOD, correct.
Thank you.
Mhm.
Next, we have number 18, Mr. Felton Thomas.
Judge, did you do a stay away on that last case?
Yes, it'll be a stay away from, I can't remember the name, but I think he is going to stay with his mother at 500 McDaniel Street. So it will be stay away from 86 Vine Street in Atlanta, Georgia.
And that was $1,000 good bond?
Yes, sir.
Thank you.
Okay. This is State versus Felton Thomas, accused of simple battery on May 17th, 2023. And Mr. Thomas, you've been advised of your right to remain silent, and your attorney is Mr. Judd. Any priors, Mr. Howard?
43 total. Last arrest was April, trespass. That's open in state court.
Okay, and that's the 344G case?
Correct. Got an open theft by taking, a 21 CR case. Two appears from last year, one from 2021, shoplifting conviction 2019, 2010 simple battery conviction, and a 07 criminal damage to property conviction.
All right, thank you. Mr. Young? Yes, sir.
Yes, Your Honor. This incident occurred at the Lindbergh MARTA station located at 2420 Piedmont Avenue in Atlanta. MARTA police were dispatched to a call inside this location, and when they arrived, the victim was yelling for help and pointing at the accused. When they spoke to the victim, she stated that the defendant chased her and grabbed her before she ran into the station for police help. Due to his battery convictions and history of FTA and his 42 arrests, the state is asking for a $3,000 surety bond, no further contact with Tina Taylor. Would also ask the court to sign for her when appropriate if she is on the Zoom call, and a stay away from the Lindbergh MARTA location.
Tina Taylor? All right, Mr. Judd?
Yes, Your Honor. Mr. Felton Thomas is 54 years old. He has lived in Georgia his entire life. He is a Grady baby. He went to Sylvan High here in Atlanta, and he is a graduate of Sylvan High. Your Honor, he is okay with a no further contact with the complaining witness. He is okay with a stay away order. We would only ask that he be allowed to travel through that station should he be on the MARTA bus or MARTA train rather. Your Honor, Mr. Thomas maintains that they were drinking together. He never touched her. She walked away. He asked where she was going, and she started screaming. Your Honor, we would ask that he be considered for a signature bond today, since he doesn't really have many bond contacts to be able to help him out with a good bond, Your Honor. And furthermore, he does not qualify for the continued use of the public defender's office after the purposes of bond.
Oh, where is he employed?
Your Honor, he has been with Staffstone Temp Agency. He has been doing warehouse work with them for about 5 years, so fairly stable employment.
All right, 21 CR 002473G. Okay. On the simple battery, the bond is going to be set at 1,500. That's a surety bond. He's to have no further contact with Tina Taylor and to stay away from all MARTA property, including trains and buses. And we're going to reset this case to June 1st, SAP calendar, along with the companion case, which also involves another MARTA situation. And that is 23 CR 002344G. He's got a third case, 21 CR 002473G, but I don't know if that case has been closed out. or whether he's got a bench warrant for that case.
Can you give me the number again? 21CR00.
21CR0024739. Did I get that right?
That's too many numbers. 002473.
No.
9 is that's too many numbers.
Yeah, I'm sorry. I just pulled up under cases, so give me a moment. (21 CR 002473G). And if that's an open case, all 3 cases would have to be reset to the SAP calendar.
Yes, judges, it is open and I'll make sure they all are reset.
Okay, thank you. Next case, please.
Thank you, Your Honor.
The next case should be Mr. Patrick Ennis. He wasn't on the full sheet nor the calendar.
May I have a
add-on calendar?
Is there an add-on calendar?
No, Judge, I sent that information over to who can assist me on it. I think I CC you, Mr. Walker, on the case. Did you read your email?
I received it and I have filed down the accusation. We're just waiting for.
So accusation was filed out. Nobody contacted me to inform me that.
You're always the last to know, Miss Lewis.
I know.
What's the booking number, by the way?
Let me pull it up, Your Honor.
His booking number is 230-7765. And let me go and see if I can get that accusation process.
All right, Officer Norris, do you have any other cases besides Mr. Ennis?
He's the last one, Your Honor.
All right, if you could wait a few moments, I'm going to get his accusation number and then I can address the case, okay?
Not a problem, Your Honor.
All right, while we are waiting, Miss Wills, you had 2 cases in which you had, can we address Mr. Saylor's case without going into a breakout?
Yes, I believe so, yes.
Okay, so this is position 14, 23 CR 003106J, State versus Elsa Saylor, accused of criminal trespass and misdemeanor terroristic threats from May 16, 2023. Mr. Saylor is not present. His counsel with the PD's office, Kelly Willis, has waived his presence. And Mr. Howard, do you have the GCIC for position 14?
6 arrests, last arrest in 1987.
What was the most recent besides this one?
1987.
87. That was the last one? I know I'm asking you multiple times, so I just want to be sure.
Yes, Judge, that was the last one. 1987.
Understood. Thank you. And Mr. Young, yes, sir, we've got a criminal trespass and terroristic threats.
Yes, Your Honor. This case has been reset 3 times this week. So what's been going on with this case is that on this day, law enforcement was flagged down in reference to the defendant who has been previously trespassed from 2686 Metropolitan Parkway, Southwest in Atlanta. Okay. And when he was approached, he was struck. When the officer approached him, he had a rock in his hand. He had threatened to hit the officer with it. If he touched him before he turned and walked away, he started to cross the roadway, ignoring commands from the officer, threatening to hit the officer with it. Other law enforcement arrived when the accused was taken into custody. The victim in this case is kind of 2-part. John Berry, he is the property manager. He is the manager at the Kroger at this location. And then there's another victim. I don't know if she would qualify as a victim. Her name is Jackie Walker. She lives in New York. So this defendant has been coming to this location, damaging electrical wires and plumbing, causing all type of problems and damaging the electrical wires. Along with this property, and there are two others, and which had to close because he kept attacking the electrical wires. They believe he's going to get seriously hurt because he continues to do this. He pulled the wires out from the towers, which are high voltage, which would cause him to electrocute himself. He also cracked open the concrete sewer vents and stuffed them with garbage. Ms. Walker stated that in each incident, they fix the damage, but he comes back and does it again. He also stuffed the car exhaust pipes with garbage, which can be a threat to the public. And PAD has come out and tried to talk with him, but he becomes aggressive with them. They were told not to call them anymore, call the police. Ms. Walker said that she does believe the defendant has mental health issues and would like that be addressed. I'm unsure if John Berry or Miss Jackie Walker is on the Zoom. They have been over the last, I believe she is. Ms. Walker's on there. She can further elaborate.
Okay.
And the state's recommendation, there's already a $3,100 surety bond. I'm going to go with that. It's $600 on the criminal trespass and $2,000 for the terroristic threats. Stay away from this location. And I believe it's been recommended a mental health or behavioral health evaluation and treatment.
All right, thank you. Ms. Walker, my name is Judge Law. If you'd like to address the court, could you unmute, please?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right, what would you like to tell me?
So the issue we're having here is that he is really willfully and with a great amount of anger destroying our property over the course of the last 2 months. For example, with the drain pipe, he used to be a metal cap. He unscrewed it, stuffed garbage down the drain, which of course I have to remediate and also causes significant injury to our tenants. But then we cemented that pipe closed. He willfully took rocks from the ground, smashes open the concrete, and does it again. So the fact that he keeps repeating his actions that are dangerous, to me does show an element of willfulness and knowledge. The parking lot lights, he has on 3 occasions wiped out all of our high voltage electrical lights. And he's not only busting open the compartments to say, take a little bit of copper, but he's actually crossing the wires as if he's an electrician trying to accomplish something. So when we go to fix it, the wires are like actually crisscrossed. So he has caused 3 times complete outages of our parking lot, which is an immense cost because I have to rent lights, get electricians out there, get new copper and everything. It's a very expensive process to fix. And then on 2 other occasions, he caused temporary outages of partial lighting systems. He's also just vandalized the place. He's broken into our tenants' trash compactors, creating massive messes in our lots. It's a nuisance, and I really do need your help handling it because it's getting out of control.
All right, thank you. Ms. Wills, do you have anything else to add?
Just briefly, Your Honor, my client is 66 years old. This incident occurred on the 16th and he was arrested on that date, or this most recent incident. My client is indigent to my understanding. His case has had to be reset twice. He has been unable to appear before the court. Mr. Derek Howard did go out to the jail and have the opportunity to observe Mr. Saylor and speak with him briefly. I will be filing all the necessary paperwork for him to receive the necessary evaluations at the conclusion of court. I would ask for a reasonable bond to be set in his case.
Count 1 is $2,500. Count 2 is $2,500. That's a $5,000 surety bond. understand there's going to be an evaluation done. To what date should I reset it?
I'm not sure at this time how long it's taking for evaluations.
So presently, I'm going to reset it to. Okay, let me see. It will be the June 1st, 11 a.m. calendar.
Judge, that'll be too soon. Can we put it out a little further? Because that paperwork won't be back in. Can we, because it's normally 4 to 6 weeks, so we can try for June.
Okay,
June the 15th or the 22nd?
I'm going with June 15th at 11 a.m. And he's to stay 500 yards away from the Kroger at 2685 Metropolitan Parkway. Have no further violent contact with Mr. John Barry, and I'm so sorry, Mr. Young, what was Ms. Walker's first name?
Jacqueline.
Jacqueline Walker, with a Q. All right, thank you.
And Your Honor, would it be possible for Mr. Saylor to be placed on a competency calendar?
That's the calendar.
That is the competency calendar.
Oh, okay. Thank you.
June 15th at 11 a.m. and that would be pending the results of the evaluation. Thank you. All right, moving on to have we received the accusation for Mr. Ennis?
Yes, Judge, I just went and talked to the person who's initiated. Yep, they're here. Let me get you the case number. Give me 1 second.
Okay. And then the last case with Ms. Wills is going to be in a breakup. Is that correct, Ms. Wills?
Yes, Your Honor.
And that was position, was it?
9.
9, okay. Let me see. Once I get, okay, can we, while we're waiting on the accusation number, who is, I think, well, Miss Lewis is also doing.
Yes, I'm the one-man show today.
All right.
I got you.
All right, you need to place Miss Wills, Mr. Young, Mr. Walker, and myself in the breakup, please.
Judge, quickly, for position number 14, that was a no further violent contact, correct?
Correct.
Well,
With
thank
John
you.
Barry and
John Barry
Walker.
and Jacqueline Walker.
Yes, ma'am. All right, Ms. Lewis,
The number is gonna be 23CR
23CR
00 3199H as in Henry. And I'm sending out a little counter to everybody, and the accusation is already filed into the case.
All right, thank you. 23CR 003199H. Okay. This is State versus Patrick Joseph Ennis, ENNIS. This case has been formally accused pursuant after Mr. Ennis was booked at the Fulton County Jail on an outstanding warrant issued by the Roswell Police Department. Mr. Ennis, you've been charged with an unlawful conduct during a 911 call. And this accusation was filed today by the Solicitor General's Office of Fulton County. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and currently you're going to be represented by Ms. Kelly Wills. And Mr. Howard, would you happen to have
nope.
his GCIC?
I don't.
Okay. Mr. Walker, would you happen to have his GCIC?
Yes, the only thing that I'm showing open is a DUI. That's from 2021. I think that's the closest infraction or cycle that's on his GCIC.
Which jurisdiction?
Yes. It's Fulton County State Court.
Oh, okay.
And in this case, on August the 10th of last year, Roswell PD responded to 1400 Riverwood Lane in regards to a caller identified as the defendant who called and asked for police to come out due to fireworks being lit off into the neighborhood. It was evening time, and when they arrived at his residence, the officers observed that TV was on and they heard people, or they heard an individual inside the home. They attempted to make contact with the caller by knocking on the door. He refused to come. At that time, the defendant then texted 911 and informed the 911 dispatcher he was not coming out, and told 911 to relay to the officers that they need to do their effing job. This went on for quite some time. At that time, when it became clear that the caller was not serious about these incidents, the police went back to the department, I guess. At the time, a warrant was taken out for his arrest. There is a $10,000 surety bond. The state is going to be requesting a $2,500 surety bond. That's it, Your Honor.
All right. Ms. Wills?
Thank you, Judge. Mr. Ennis has resided in the state of Georgia for the past 8 years. He does have a vocational degree in drafting and three-dimensional modeling. He's employed as a bin designer for PES Structural Engineers, and he has been employed there for the past 7 months and will not qualify for our services moving forward. I would ask for a reasonable bond to be set. In this case, I would ask for a signature on bond, and if Your Honor is not so inclined, I would ask for a $750 or $500 surety bond, excuse me.
All right. Bond's going to be set at $1,500. It's going to be a surety bond. No further contact with the Roswell Police Department unless there is a bona fide claim for an alleged criminal activity, which requires interference by the law enforcement. Any other use of profane language or abusive language or harassing language with regards to the Roswell Police Department will result in Mr. Ennis's bond being revoked. No illegal drugs, no alcohol, no weapons, and no firearms. We're going to reset this case along with the other open case, which is 21 CR 002778H to the SAP calendar. But in the meantime, with regards to the latter case, the DUI 21 CR case, Mr. Ennis is scheduled for trial before Judge Taylor on June 14th, 2023. From what I gather, his attorney, Mr. Serge Jerome, is planning to withdraw as counsel. So, Mr. Ennis, I recommend that from this moment onwards, you either reach out to Mr. Jerome or hire another attorney, because you will need to be prepared for both these cases. Thank you. All right, let's go over the calendar, please. So for Mr. Ennis, that would be the add-on position 1, and that would be a $1,500 surety bond reset to June 1st, along with the other open case that I just mentioned. And then going back to the main SEA calendar, position 1 Baker, that was a $3,500 surety bond reset to June 1st. Position 2 Campbell's a 5,000 signature bond for pretrial per the notice. Position 3 Conley's 3,500 signature bond for pretrial per the notice. Position 4 Conley, the son, is a $3,500 signature bond through pretrial for the notice. Position 5 Dr. Dames is a 2,000 signature bond through pretrial for the notice. 6 Dixon is a 5,000 surety bond reset June 1st. Yeah. Position 7, Gantt, is a 3,000 signature bond through pretrial for the notice. 8, Grant is a $4,000 surety bond reset June 1st. 9, Leak is a medical reset. Not a medical reset. Appearance was waived, and the bond is 3,000 surety reset to June 15th at 11 a.m. Position 10 was already addressed yesterday. Position 11, Oliver, is a 5,000 signature bond through pretrial for the notice. 12, Owens is a $1,500 surety bond. Reset date is June 1st. I'm sorry, that's a 1,500 split bond. I think it was a 500 signature bond through the jail on the pedestrian charge.
That's correct, Your Honor.
All right. 13, Roland was a $5,000 surety bond, reset date June 1st. 14, Sailor, appearance was waived, it's a $5,000 surety bond. Reset date is June 15th at 11 a.m. competency. Position 15, Salad's a $3,000 signature bond through pretrial for the notice. 16, Sims is a $2,000 split bond. Reset date June 1st. Position 17 is a $1,000 surety bond. Reset date June 1st. 18 is a $1,500 surety bond. Reset June 1st, along with the 21 CR case.
Judge, for the add-on calendar, I logged myself out. Can you give me the conditions? I have $1,500 good bond and the no further contact with Roswell Police Department. Was it a stay away? I have the
No further calls to the Roswell Police Department unless there is a bona fide reason that police, like for criminal activity, which requires police to come in.
Okay.
In other words, no harassing or calls without a purpose.
Okay.
No alcohol and no drugs and no weapons.
Okay.
That's it.
Thank you.
All right. And he's got that other case with Judge Mather. Oh, no, not Judge Mather, Judge Taylor. That needs to be set on SAP also on June 1st. All right, ladies and gentlemen, that concludes the, I think, our C calendar for this week until tomorrow. So I wish you all a very pleasant evening.
I did it. Thank you.
Thank you.
Thank you, Your Honor.
Bye-bye. Miss Lewis, good job. 2 Kit Kat bars. Okay, thank you.